So while we've understood and gone through the requirements of a Section 11 application as to when a Section 11 application has to be filed, the prerequisites of a Section 11 application, it is equally important to see from a practical perspective what an actual Section 11 application looks like. In our case, what we have with us is a template, as you can see, of a Section 11 application which is filed before the Bombay High Court. Now, what are the contents or how does a Section 11 application look? So, firstly, you begin with the cause title, which mentions the court before whom the particular arbitration application under Section 11 is filed. Then, on the right hand side of the cause title, you see the details of the act under which it is filed, that is, in the matter of the Arbitration and Conciliation Act 1996. The section under which it is filed, which is obviously a Section 11 of the Arbitration and Conciliation Act 96 as amended, and then the clause in the particular agreement which encapsulates the arbitration agreement between the parties. So that clause will also have to be mentioned in the cause title. Then comes your long title, where the details of the applicant company, the one who's actually moving this application or filing this Section 11 application, and then the other parties, those are the respondents who have refused to nominate or comply with the requirements of the arbitration clause by not nominating their arbitrator. It is addressed to the Chief Justice and other judges of the Honorable Bombay High Court. This is a normal format that I am reading. And then when you begin the application, it begins with a brief introduction of the applicant, in this case a company, as to the company which is formed under the Companies Act, where the office of the company is located, the business that it is engaged in. Similar details of the respondent company will also have to be mentioned. The most important point over here is point 3, as you see. It speaks about the actual agreement in which the arbitration agreement has been encapsulated. Now, why this becomes important, this particular thing, I'll first read it out. The applicant submits that the differences and disputes have arisen under and in connection with an agreement dated so and so date. The applicant states that the said agreement contains an arbitration clause, and this clause is then supposed to be reproduced. Why this becomes important? In the beginning of the lecture, as I've touched upon Section 11.6a, what it says is that the court, while considering a Section 11 application, will only have to go into or ascertain that an arbitration agreement exists. Now, this furthers the case by giving details of the arbitration agreement. You drive the attention of the court that there indeed is an arbitration agreement in the contract which has been entered into between the parties. So this is one of your important factors that you need to highlight before a court. Attach the copy of the agreement as an annexure. Then, like we discussed, that there often are conditions under which prior to submitting disputes to arbitration, parties are supposed to try and resolve the disputes amicably. So it is mentioned in para 4 that the applicant states, as more particularly set out hereinafter, the parties have been unable to amicably resolve the various disputes and differences that have arisen under and in connection with the agreement. It is submitted that these disputes and differences are within the scope of arbitration agreement contained in the said agreement. So it relates to that portion of the agreement which says that this particular disputes and differences will be relegated to arbitration. Then we have to give details of the notice that the claimant has given, by which it has appointed its nominee arbitrator, and then also make an amendment that the respondents have failed or neglected to appoint their nominee arbitrator. And that is why this particular application has been filed, which is mentioned in point 6. In these circumstances, the applicant is constrained to approach this honorable court under Section 11 of the Arbitration and Conciliation Act 1996 as amended, seeking the appointment of the respondent's arbitrator. Because in this case, the respondent has refused to appoint its arbitrator, the party has moved a Section 11 application seeking an order from the court for appointment of the respondent's arbitrator so that an arbitral tribunal to adjudicate the disputes and differences that have arisen under the said agreement between the applicant and respondent can be constituted. For the benefit of the court, for it to know the factual matrix of the matter, give the details of the facts involved in the matter leading up to the stage of the disputes. Then comes some of the boilerplate amendments. Those are the agreement provides that the courts in Mumbai will have exclusive jurisdiction over disputes arising out of the agreement. Here you have to mention the courts in Mumbai are exclusive jurisdiction because the arbitration clause must have encapsulated Mumbai as the seat of the arbitration. The applicant therefore submits that this honorable court has exclusive jurisdiction to entertain, try, and dispose of this application. This is your clause which says that Mumbai courts will have exclusive jurisdiction. Then you reserve your right on behalf of the applicant craves leave to add to, modify, substitute, delete any part of the foregoing if necessary. The applicant has paid the requisite court fees in relation to this application. The applicant will rely upon documents, a list of which is annexed hereto. The applicant submits that the present application has been filed within the period of limitation and no part of the applicant's claim is barred by law of limitation. And then the details of the authorized signatory who's executing or affirming this particular application on behalf of the applicant. And then the vital part, the prayers. What are you asking from the court? What reliefs are you seeking from the court? That would be, in view of the above facts and circumstances, the applicant most humbly and respectfully prays A. That this honorable court, in exercise of its power under section 11(6) of the Arbitration Act, be pleased to appoint an arbitrator on behalf of the respondents for references of the disputes between parties hereto as per the agreement dated so and so at Exhibit A hereto, and for such other and other reliefs as the nature and circumstances may require, signed on behalf of the applicant. It also has to be signed by the advocates for the applicant. And then comes the standard verification clause, which reads that I, so and so, the authorized signatory of the applicant, having my address at so and so, hereby state that whatever is stated in paragraphs so and so to so and so is true to my own knowledge. Those are the factual details. And what is stated in paragraph dash to dash is based on information and belief, and I believe the same to be true, solemnly declared at Mumbai. The date of execution, against to be signed by the applicant's advocates and then signed by the authorized signatory of the applicant. So this is how a section 11 application normally looks.